So what are you guys doing? Hope you guys are doing amazingly well. Yeah. So what we'll see? So we'll see section 23. We'll see section 23. We'll just revise section 23. Public company. Public company, if they want, they can issue securities. How? Either through prospectus to the public or private placements or right issue or bonus issue. Yes or no? Yes. And they have to comply. And they have to comply what? Companies Act and SEBI Act and the rules and regulations of SEBI if it is a listed company. And if it is an unlisted company, they have to comply Companies Act. So yes or no? Yes. And if it is a public offer includes what? One is initial public offer. Next is further public offer. Yes, IPO, FPO. Then offer for sale of securities. This who will do? This existing shareholders give it to the public. We'll discuss this little later more in detail in a section. Private company may issue securities. Private company may issue securities through private placement, through right issue, through bonus issue. Yes, by complying the provision of Companies Act. I want to make a revision. Okay. So yes or no? Yes. So company is giving public what? A prospectus. Yes, and they are giving, public is giving money. Public is giving money. Public is giving money. Okay. This money has been utilized as per, this money is utilized as per what has been mentioned the prospectus and all. Yes, but this money is unutilized. It is yes, it is unutilized. It is unutilized and company want to change the terms. Company wants to change. Oh God. It is unutilized and company wants to change. Change what? Change the terms of contract in the prospectus, or company wants to change the object. Company wants to change the object. Say yes or no. So so can they do this? Can they do this? Yes, they can do this. They can do this. How? For this, a special resolution to be passed. For this, a special resolution to be passed. For a special resolution to be passed. So special special resolution to be, for a special resolution to be passed, what? You have to give a notice. You have to give a notice. Yes. This notice, one individual notice. One is individual notice. One is individual notice. Okay. This notice we saw in Rule 7. We saw in Rule 7. So please concentrate. Please concentrate. We saw in Rule 7 that what and all are the details that has to be mentioned in the notice. Yes, that should be mentioned. Okay. So please concentrate. Yes. Along with this notice. Okay. That should be given. Next. Advertisement. Advertisement 1 in English newspaper. Next is vernacular newspaper. And in which form, sir? Form PAS1. Form PAS1. Sorry, sir. Sir. Yes. This advertisement will justify. Why? Will say what is the justification for the change. What is the justification for the change? Okay. Along with this advertisement, you will also give a postal ballot. You will give a postal ballot notice also. You will give a postal ballot notice also along with this. Yeah. Yes. Next. This notice you will also mention in the website. You will also give it in a website, if any. If any. What does this if any means? If company is having a website, company will put it in the website. If company is not having a website, they won't. Yeah. After this, what will happen? After this, what will happen? Superb. A special resolution will be passed. Special resolution will be passed. A special resolution is passed. If it is failed, what? You cannot do the change. You cannot do the change. Special resolution will be passed. If special resolution is passed, okay? Then what now? What about dissenting shareholders? What about dissenting shareholders? Who's this dissenting shareholders? Who's this dissenting shareholders? They are the shareholders who went against it, but still special resolution is passed. Yes. What about them? They have given given an opportunity. They are given an opportunity. Opportunity. By whom? By opportunity has been given by whom? By promoter, by controlling shareholder. Who is this controlling shareholder? Who voted in favor? Who voted in favor is a controlling shareholder. What they will give? They will give an exit offer. What opportunity are they giving? They giving an exit offer. Leave the company if you want. Yes, if you want, leave the company. They are giving this opportunity. Yes, if dissenting shareholders taking it, dissenting shareholders will get an exit price. Will get an exit price. This exit price given to dissenting shareholders. Given to dissenting shareholders, this exit price will be what? This exit price will be mentioned in SEBI regulation, and also with the, also this how exit offer is made, the manner, what are the conditions to do exit offer. This and all will be mentioned in SEBI regulations. Yes or no? Yes. And next is what? If company want to invest in other listed company equity shares, they cannot do it. They cannot what? They cannot buy. They cannot trade, or for any other purpose they cannot do it. Yes, sir. Yes, sir. I want again to do a revision because I want to do it. Company prospectus to the public, some amount. It has been utilized. It has been utilized with the prospectus. Section 27 will not be applicable. It is still not utilized. Still, what section 27 will not apply. But company wants to do what? Company wants to change the terms of contract or object. In that situation, section 27 will be applicable. And what they will do? First, they will give a notice to whom? To the shareholders. Individual notice. We have seen in Rule 7 what are the details. What are the details? Yes. The next they will give an advertisement. They will give an advertisement in form PAS1. One in English newspaper and another in vernacular newspaper where the registered office is situated. Where the registered office is situated. And along with it, they'll give a postal ballot. What is this postal ballot? It is kind of a voting. It is kind of a voting. Yes, they'll give a postal ballot, and also this notice also will be in the website. The voting will be done. A special resolution will be passed. So what about dissenting shareholders? An opportunity is given to the dissenting shareholders by whom? By promoter and controlling shareholder that leave. If you want, leave the company. Yes, and this exit price will be given to dissenting shareholders. So what will be the amount? That will be mentioned in SEBI regulation. What are the manner and condition? That also will be mentioned in SEBI regulation. Sir, yes or no? Yes. Sir, I have to do section 26 revision. Can I revise that when I'm doing section 27 revision? I have to even revise section 27. Yes. While doing this section 27 revision, I will also do I have to even do section 27 revision? I did it. So next session, when we will do section 26 revision, okay? Okay? Yeah. Thank you. I didn't even revise section. We finished section 26, we finished section 27. I didn't revise section 26 also. Yeah. So we'll revise section 26 along with it. Simultaneously, we'll revise section 27. Then we'll see what are we gonna see in this session. Yeah. Yeah. Let's begin. Section 26. What is it saying that public company is issuing prospectus. Public company is issuing prospectus. The prospectus should be dated. The prospectus should be signed, and the prospectus should contain information which SEBI special. What information? Few information and report on financial information which SEBI specify in its regulation. Until SEBI specifies later on something else, until that what and all has been specified in SEBI Act 1990 in its regulation, you have to comply. Yeah. Public company makes a declaration what that public company has complied Companies Act 2013, and also the prospectus is not contrary with, which means prospectus is inconsistent with, is consistent with, is consistent with Companies Act, SCRA, SEBI, SCRA Securities Contract Regulation Act 1956. Section 26. Section 26 is not applicable to whom? I mean, Section 26, subsection 1 is not applicable to whom? To existing members and existing debenture holders. Even if this particular member can what? Renounce the right share. Renounce the right share, it doesn't matter. And this shares or debentures has been previously issued. The shares or debentures has been previously issued. The same shares, yes, and it is still being dealt in recognized stock exchange. Then section 26 subsection will not be applicable. Date, we have already seen that the prospectus date will be indicated. Yes, this date shall be deemed as date of publication. It will be considered as date of publication, and on or before date of publication, company has to do what? On or before date of publication, company will do what? Company has to file with the registrar. Yes, a copy of its prospectus. Which shall be, and also prospectus will be signed by whom? Director, proposed director, and duly authorized attorney. Yes or no? Yes. And prospectus shall state what? State what? That I have filed. Public company has filed with the registrar the prospectus, and also that what and all other documents which has been in the prospectus that also to be mentioned, such as expert written consent that has been there. All those particular things will be mentioned that this is there. All these, yeah, these documents are there. Prospectus shall be valid. Prospectus shall be valid what? Within 90 days. But in exam, will you write within 90 days? No. Not more than 90 days. What you should not issue. We should issue within 90 days. But don't write within 90 days, right? Public company has to issue its prospectus and not more than 90 days. Yes, yes. And if prospectus with respect to this section has been contravened, then what to do? What to do? Minimum 50,000, maximum 3 lakhs. For whom? For whom? Fine. For company and person who knowingly a party to the issue. Yeah. So we will even see section 27. What does it say? So section 27 we have already revised. I have given some flowchart kind of a thing. It is more understandable, but we'll even see the what? A detailed explanation. Company shall not vary what? The terms of contract or the object, yes. But if company wants to vary, what? How can it vary? By passing a special resolution. For this to pass a special resolution, you have to give a notice that please come and please make sure that pass a special resolution so that I can vary the terms of contract and object. Yes, yes. So that by giving a notice, by members can know that what is the justification, what is the reason you are changing it, what is the reason you are changing it. Yes, yes. And also you will give notice in English newspaper and vernacular newspaper. Yes, also please come on next. Simultaneously you will also dispatch postal ballot notice. Postal ballot, please wait for chapter 7. You will know this is a type of voting. This is a type of voting. There is a separate section for this. Okay. Okay. companies shall use any amount raised by the prospectus from buying the equity shareholders. Yes, no, they cannot. They cannot buy equity shareholders of listed company. Any listed company they cannot buy. They cannot trade. So what about dissenting shareholders? Dissenting shareholders, what they have the they can move out. They can they have the power of exit offer. With the power of exit offer, they can these dissenting shareholders can and they don't have to be any more the shareholder for that. They are what exit price. They take the exit price and leave. Yeah, and this exit price and manner and condition of exit offer is specified in the SEBI regulation. Is specified in the SEBI regulation. Is a yes or no? Yes. So what are we gonna see? So first we'll see section 29. We'll revise section 29. Public company, and every unlisted public company what will issue the securities in demat form. And if securities of unlisted public company wants to transfer their securities or want to hold their security, it should be in demat form. And private company, if they want to issue the securities, they can issue either in physical form or they can issue in demat form. If private companies having their shares in physical form, they can what? They can convert it into physical form. And this now Rule 9A is applicable to whom? It is applicable only to unlisted public company. It is applicable only to unlisted public company. Yes. And this unlisted public company will issue securities only in demat form. And even they will what they will convert their existing securities into demat form. Sir, yes or no? Yes, and they will what they will also inform. They will inform the existing security holders about the what the conversion. Yeah, unless the public company will ensure. Unless the public company will ensure what they will ensure. What they will ensure, sir. They have to they have to convert few people securities into demat form. Who are those people? One is director, next is promoter, next is key managing person. After that only they can issue super bonus share, right share, private placement, also buyback. Yeah. And if on or after 2nd October 2018, if security holder wants to transfer the securities first, those securities has to be in demand form. Then only they can issue the securities. Also on or after 2nd October 2018, if they want to please, if they want to subscribe to the securities, they have to ensure that the existing securities has to be converted into demat form. Then only they can subscribe to the new whether new securities, by way of private placement, bonus shares or right shares, yes or no. Yes. Now, unless the public company will get what ISIN. What is ISIN? International Security Identification Number. But for each type of security, unlisted company will be getting it. And what? And unlisted public company will make payment. What payment? Admission fee, annual fee, and security deposit. The security deposit for at least for 2 years, at least for minimum for 2 years at least. What security deposit has to be given? Sir, yes or no? Yes or no? What if payment has not been given to depositor or registered to an issuer share transfer agent? In that case, unlisted public company cannot issue securities by private placement, bonus shares, or right shares, or also buyback. Yeah, an unlisted public company has to comply what is in the Depositories Act and SEBI regulation. Also the circular the regulation, direction, and guidelines also has to be complied. Yeah. Then Form PA6, which has to be certified by chartered accountant or company secretary in practice, has to be filed with the register within 60 days for each half yearly. And this 6 month and this 60 days will start from when? From conclusion of each half yearly. Yeah. So all this I have explained. I'm just revising now. Please don't expect that I have to again teach you. Yeah. unless the public company will file grievance to whom? To Investor Education Protection Fund Authority, to Investor Education Protection Fund Authority, and this authority will do what? Before taking any action, they will first consult SEBI and they will take action against they are registered to an issue share transfer agent, depository or depository participant. Yes, and this particular rule is not applicable to Nidhi company, not applied to Nidhi company, then government company, then wholly owned subsidiary. Sir, yes or no? Yes. So today first we will see, revise section 31, which is self-prospectus. Then we later go on to a new section. Section 31. Self-prospectus, if they want to issue a prospectus where they don't have to issue further, keep on issuing further prospectus for a certain period, then they can issue self-prospectus. So for whom self-prospectus will be applicable? It will be applicable for certain class of companies which SEBI specifies. And these companies will file a self-prospectus with the register. When will they file? At the time of first offer of securities. When they are issuing for the very first time self-prospectus, they will file with the registrar. Self-prospectus will contain, what will it contain? It will contain the period that not more than 1 year. It can the validity of self prospectus is not more than 1 year. Till 1 year, you don't have to keep on issuing further prospectus. So from 1 year from when? So 1 year from the date of opening of first offer of issuing the securities. No further prospectus is required, which is you're issuing the share prospectus for the first time, then you don't have to keep on issuing new prospectus for second or subsequent time. Company will file with the register. What will it will file? It will file, of course, with share prospectus, it will file. It will also file information memorandum. Information memorandum containing all facts relating to new shares, changes in the financial position, and any other any other changes. For example, a person has made an advance for shelf prospectus, but company has made some changes which before that changes itself he has given an advance. Then the company will convey that information to the person, and if that person decides, the person who has given the advance decides, then he has the power to withdraw the application. Then company has to refund the amount within 15 days. Company will file information memorandum every time while they are offering the securities, and self prospectus plus memorandum is prospectus. We have done section till 40. We have done complete chapter 1, chapter 3, part 1. Chapter 3, part 1, we have completed, but I didn't revise section 35, 34, 36, 37, 39, and 40. I didn't revise, so I thought that should I revise or not. So if you have already revised, the reason is why I didn't revise immediately. Immediately is because what along while I was explaining, I even mentioned is a side by side. So I thought that I don't need it, but you don't have to complain tomorrow. You don't have to complain tomorrow. So you didn't do that revision. So I thought, okay, fine, I'll do it. We'll do a very fast revision. We know the concept. We'll do a very fast revision. Okay. Okay. So person subscribe. So we'll start with section 35. The person subscribed the securities, but he incurred losses or damage. Why incurred loss or damage? In the prospectus, it has been mentioned what a statement or any matter or omission has been made in the prospectus. This inclusion of the matter or omission of the matter or statement in the prospectus. These and all are what? These and all are misleading. If these and all are misleading, misleading person, no, these persons will be what? Compensated. These persons will be compensated. Yes, and along with it, yeah, even 36, even section 36 also will be applicable because it is compensated. It's not like section 36 liability will be waived off. No, that is not the situation. And how compensation will be made? company and every person. Who are those persons? Director, who at the time of issue of prospectus, director who has agreed immediately or after further period of time or for the interval of time. I'm sorry, for the interval of time or a person he authorized himself to be the director, that we saw in what section 25, offer for sale of securities, then prospectors, promoters, then expert, then so please tell the last one, who has authorized the issue of prospectus. These persons will be liable, yes, but these persons will not be liable in the following cases. Why these persons will not be liable? If they prove that director has director has given his consent to become the director. He withdrew the consent before issue of prospectus. He withdrew the consent before the issue of prospectus, and also what he has he has given no authority or consent for what issue of prospectus. Then he will not be liable. Then any person without their knowledge or consent, prospectus has been issued. Then what they have to do immediately after they knowing about it, they will issue what? They will issue a public notice that we were unaware, we have no knowledge or we didn't give any consent. This public notice will be given, yes or no, yes. An expert will give what? Expert will give a statement or report of valuation, yes or no, yes. And they believe that what they have given, correct and fair representation has been given, and what? And they are competent to make it. It's not like they are not competent. They are competent to make it, and also expert has given his consent and he didn't withdraw. What consent he has given? That you can mention this in the prospectus. Yes. Next. So this is compensation, but prospectus has been what? Prospectus has include the statement or matters, but what this is to defraud. If this is to defraud whom? The applicant or any other person, or for any fraudulent purpose. Then in that situation, section 447 will be applicable. In that and not section 447. Sorry, the person who has incurred loss or damage, what will be liable? So who's personally liable? Who's in section 35? There are 4 people: promoters, who has authorized the articles, expert, and directors. These persons will be personally liable, yes or no? Yes, without any limitation of liability. Then section 34. So what is section 34? What is section 34? If statement matter matter in the prospectus or omission in the prospectus is untrue or misleading, then in that situation, who will be liable? Person who has authorized the issue of prospectus, he authorizes the issue of prospectus, they will be liable under section 447. Yes. And but the person so when he will not be liable under section 447, what omission or what inclusion in the matter or what statement he has given, it is though it is what untrue or though it is misleading, it is immaterial. Then he will not be liable. Or the person who was authorized believes up to the issue of prospectus that it is true. Third one, what is the situation? Inclusion or omission is necessary. In these cases, what? In these cases, suppose he is not liable. So I even gave examples also. I hope you guys remember. Next, section 36. What is section 36 talking about? A person is promising, or he's what is he doing? He's forecasting or he's giving a statement. But all these are either false or misleading or deceptive or deliberately is concealing any material facts. Then what? Why he is doing all this? To enter into an agreement. Then he will be liable under section 447. So what are the agreements? One, he is acquiring or disposing of the security. 1. 2, for obtaining the credit facility. 3 for the agreement that fluctuation will happen because of the profit. You will yield profits. All these are the false promises and false forecasts has been made for what? For him to induce these agreements. For him to induce these agreements. Then section 447 will be applicable. Next, section 37. What is section 37? Any person, group of person or association of person, what if they want, they can file a suit, or under section 34, 35, 36, what is the compensation or for 447, they will be liable. Yes, who will file the case, who is affected by any misleading statement or omission of any matter, yes or no? Yes. Sir, do we have to revise section 39? Section 39 what? I mentioned, I don't know. Do we have to? Okay, we'll revise it. We'll revise it because we'll revise it. Company makes an offer to public. So which company will make offer to the public? Public company. So public company what? If they want to, public company is making and they want to subscribe the security, when they can do? Only if minimum number of subscription has been made and application money is also received. But application money can be received either by check or by other instrument. Yes, and it should be received within 30 days. What if it is not received within 30 days? Then you have to refund. To the bank account of the applicant within 15 days. What if you have not received? What if you have not repaid? Then what? Then 15% interest along with the principal amount will be jointly and severally liable by whom? Directors who are in default. Yes. And what will be the application money? 5% of the nominal value or such amount which has been prescribed by SEBI in its regulation. That at least minimum that should be the application money. And company having share capital, they have to what? After allotment of securities, they have to file the return of allotment. And if this section have been contravened, 1,000 rupees for each day, 1 lakh, whichever is less. Section 40. What is section 40 talking about? What is section 40 talking about? One is about listing. Next is about underwriting. So first we'll see about listing. What is it talking about listing? Public company, if they want to offer securities, what they have to do? They have to do two things. What is it? One, they have to make an application to recognized stock exchanges and they have to get permission from the recognized stock exchange to be dealt with. Yes. So this has to be done. And even in the prospectus, you have to include what? You have to include that I have made the application and I have obtained the permission from these and all recognized stock exchanges. Yes, so that public applicant you can purchase from those recognized stock exchange. Application money. If you want to receive, company has to open a separate bank account in a scheduled bank. And if they want to utilize this application money, when they can utilize? Only if allotment is made. So what if allotment has not been made? And then you have to refund it. Yes or no? Yes. And what if company says that listing provision and all is not applicable? I'm waiving of this listing provision. The applicant, you have to bind according to what I say, what companies say, not Companies Act says. What in that situation, what is it? It is void. If company makes any condition like that, it is void. Yes or no? Yes. And so when will company pay underwriting commission? Only if public has not made a minimum subscription and application money. Yes, minimum subscription has not been made. Then in that case, what? Underwriter will subscribe to those securities and underwriter will get commission. But for this following conditions will be satisfied. What is the first condition? So what is the first condition? Superb. Now there are 4 type of offers securities can be given. One is right issue, bonus issue, private placement, and so please private placement and public offer. Only in case of public offer only you can give underwriting commission. In other cases, you can appoint underwriter and you can give underwriting commission. Next commission if you want to give, you have to the article has to authorize. Next what, sir? If what if article is not authorizing it, you have to alter the articles, which we saw in chapter 2. Next, Commission is payable either by profits or what amount of securities amount for the securities you have issued, you have received the amount, right? From that also you can give proceeds of issue also you can give, or both from proceeds of issue or from also with the profit, both combined you can give it to the underwriter, yes, as commission. And what will be the commission? What is the maximum commission you can give? What is the maximum commission you can give? In case of shares, 5% of the issue price, or articles as authorized, how much commission you can give, whichever is less. And how about in debentures? 2.5% of issue price, or articles authorized, how much, whichever is less. Yes or no? Yes. And prospectus should disclose what? Prospectus should disclose what? Name of the underwriter, number of securities to be underwritten, and rate and amount of commission payable to underwriter. These are the things we have discussed. Yes. And I didn't revise it. I thought I don't have to, because I should have actually. I had this guilt feeling that I didn't revise, so I'm revising it. Yes, I have revised. Yes, so do still. Thank you.